about dealing with a matter that has many parties, affects numerous people. I have not had anybody suggest that your lordship lacks the competence. And there is no law that provides that a decision of 3, 5, 7, 9, 21 is better than the decision of one judges of the same rank. My learned friend submits that Mumias owes over 30 billion. It's a significant case. What's going to happen if somebody should present a winding up petition against Safaricom, whose value is 261 trillion? We would have to take all judges to a stadium to determine that. So it is not a question of how much is involved. I am sure your lordship has dealt with cases of greater value. There is rules that determine how this is done. My lord, this application is for the reasons set out in the replying affidavit of the first respondent, not brought in good faith. I do not want to rehash the grounds. Suffice it to say, my lord, the applicant does not meet the test. I'd urge it for the reasons set out in our grounds of opposition, and on the strength of the cases we have put before you, especially the Okiya Omtata versus Anne Waigoro and Okiya Omtata versus the DPP, which requires, amongst other things, the substantial question of law to be set out in a pleading. The plaintiff in question has not filed any pleading other than this application and an affidavit on the injunction application. There is no pleading, there's no foundation at all. For these reasons, I'd urge your lordship to dismiss this application and to allow us to proceed with the arguments this afternoon. That would be all.
Counsel Orengo?
Yes, my lord, I would, at the very outset, associate myself with the submissions of Senior Counsel James Orengo, and also with the comments made, observations made by the Senior Counsel Paul Wheaton. On our part, we have filed grounds of opposition. We have filed submissions, and we have filed a list and bundle of authorities. And for that matter, I need not take too much time, but only to emphasize this, my lord. If you look at the application by the seven plaintiffs, it is brought under Article 165, sub-Article 4 of the Constitution. Those are the provisions of the law that he seeks to rely on. And because he has chosen that path, the plaintiff must comply with the requirements as pointed out by my learned friend, Senior Counsel Kimani Kiragu, with Article 165, sub-Article 4, and more importantly, sub-Article 3. My lord, in the judgment of Odunga, in a case we have cited, and it's found in paragraph 5 of our written submissions, the Republic versus the President and 5 others, ex parte Wilfrida Itolondo. Judge Odunga states quite clearly that for an application of this nature to find favor with the court, the applicant must demonstrate that the application falls within the 2 categories mentioned in Article 165(3). That is, there must be an alleged violation or denial or infringement or threat to the Bill of Rights. And secondly, and if I'm speaking broadly, the second category is that it must respect, the question must be in respect of the interpretation of the Constitution. looking at the motion, and there's a notice of motion and there's the affidavit in support, no such case is made out. And to that extent, my lord, you did not concern yourself with the question as to whether the matter is complex, or whether it brings a novel issue, or whether the question is moot. Those considerations, or because it raises a matter of public interest, those considerations can only come to play if the applicant can demonstrate that there has been a denial or violation of the Bill of Rights, or there's a question of interpretation of the Constitution. Now, my lord, if you look at the motion itself and the supporting affidavit, the question, the substantial question is not brought out, it's not crystallized in the motion. And all that the applicant was doing is go through the pleadings. It is important to mention that actually the applicant doesn't have a claim, but he was going through the pleadings to try and bring out issues contained in the pleadings. But for such an application to find favor with the court, the litigant must crystallize the substantial question. So as you make that decision, it's clear that what is the substantial question of law involved in relation to Article 165, 3 and 4. And my lord, again, looking at the application, one of the issues that is being brought out in the affidavit, which I find rather worrying, in paragraph 7 of the affidavit, is a backdoor application for your recusal. That's what I can say. It's challenging the integrity of this court. And if I may read out what it says, that in view of the scope and sensitivity of the matter, and considering how the matter was conspired by Justice Appoint for further direction by the presiding judge, it is prudent to shield the court from undue pressure. I find that rather not only amazing, but for a litigant to make such allegations in an affidavit, there must be something more concrete to demonstrate that your lordship needs protection from undue pressure. And that is undue pressure when we are ready to proceed with the application. But it's not undue pressure when orders which they find favor with, like the interim orders. When it comes to the question of interim orders, they're quite happy with the decision the court has made. Otherwise, they would have wanted to impute that initial decision, just like by a roundabout way, they are trying to question the directions.
But Senior Counsel, I don't think those orders were given in favor of the seven?
They were not given in the
Yeah,
seventh, but I'm saying
they are
they're
in
quite,
favor of the
they're
first to
yeah.
the fifth plaintiff.
Yes, but I'm saying they're quite comfortable with those orders.
Okay.
Yeah, they're quite comfortable with those orders. And nowhere have they stated that those orders were given in error. So, my lord, without, I don't want to take a lot of time on this. Our submissions are quite clear and quite lengthy on this issue. And this is what in American courts they would call Scotch Act litigation. Just to find a way of postponing litigation by application, one application after another. And assemblance of that type of litigation.
Thank you, Senior Counsel. We'll consider your submissions.
So I urge the court to dismiss them.
Very well. The other counsels who are opposing? Mr. Richard?
Yes, my lord. First and foremost,
For Mr. Richard,
for the sixth defendant, First and foremost, my lord, the matter before you was not transferred to this court. It was referred by your sister, Honorable Justice Orengo, for further action. My lord, the main plaintiffs, the original plaintiffs, Prince 1 up to 5, have not filed an application seeking to have the matter heard by more than 3 judges as there is an application applicant seeks. That means the owners of the suit are not interested in the orders that are being sought before you. As submitted by my senior learned colleague, Imani Irago, the 6th plaintiff has no claim against the defendants. Therefore, this application has no legs to stand on. My learned colleague submitted that the judgment of this court in an insolvency cause is the subject of in this matter. My lord, that's not the correct position. If this court made a decision in a different matter, the only avenue is either to seek review of the ruling or appeal. It cannot be a subject of litigation in a different course. I entirely rely on my grounds that I filed and associate myself wholly with the submissions made by my senior learned colleagues.
Counsel, there was someone else on this side. Mr. Kamal?
Yes,
Please.
my lord, on the part of the third or the seventh defendant, my lord will rely on the list and value of authorities dated 15 of February. My lord, we wish to make 2 points. That the issue before the court and the court determines whether there are substantial questions of law. The court has to be guided by the principal pages that have been covered by the parties. And in this case, my lord, the only principal pages that are before the court is the plaint as filed by the first to the 5th defendant. First, the 5th plaintiff. The 7th plaintiff applicant has not filed any principal pages before the court. Secondly, my lord, under Article 165(4), the applicant has to establish that substantial questions of law arises in this particular matter. A cursory look at the application as filed does not enumerate any substantial questions of law that will guide this court for purposes of determining whether this is a matter that calls for a panel of a bench. Thirdly, my lord, I wish to rely on the decision number 3 in our list, the decision in J. Counsel James Orengo, that's Attorney General and another, the decision of your brother Justice Majanja, that's from page 16 to page 19 of our authority. And my lord, Justice Majanja held that reference of the matter to the Chief Justice when paneling of a bench should be the exception other than the rule. And the burden is cast on the party who applies to the court to satisfy the matter for reference to Chief Justice. And in this case, my lord, it's a humble submission that the applicant has not satisfied that burden. Lastly, my lord, I rely on the decision in the Okio Mtata, that is Alfred Mabea, 2017 EKR, in the Court of Appeal decision, the decision of Justice Odunga in Martin Nyaga and others was a speaker of the County Assembly of Embu, where Justice Odunga cautioned us for some minorities around it, just in one partner, that in this country, we still do not have the luxury of granting such orders at the whims of the parties. And judicial resources in terms of judicial officers in this country are very scarce. And empanelling such a bench usually has the consequence of delaying the cases. We submit, my lord, that the invitation of this court to empanel the bench is for purposes of delaying this matter. And this court, having certified this matter as urgent, we respectfully urge this honorable court to decline the invitation by the seventh page applicant to refer this matter to the Chief Justice for empanel of a bench.
Very well. Thank
On
you
the-
so much. Yeah,
One last point for
yes.
the applicant is making a submission indicating that the subjectivity of this court is in question. The court should decline the invitation of a party to approach this court their application for certification that raises some questions of law as a backdoor approach with an application for a fee. Thank you.
Very well. Mr. Mann?
Thank you, my lord.